statutes or on the trust code or anything like that. So you're not expected to know these things, but these are things that are important to rules that are important to follow, administrative things that are important to stay on top of if you're going to be in that role. It's not necessarily just an easy thing to go through. So welcome, everybody. As I mentioned a second ago, I'm attorney Justin Randall here with Hooper Law Office. If you're rejoining us after attending our previous topic on personal representatives and handling an estate, welcome back. If you're new to the topic today, I'm going to recap some of the things I talked about too, just because I don't expect you to necessarily have to go back and rewatch everything. So our topic today is going back into what a personal representative is, what they have to do when they're administering somebody's estate, and some of the things that you're going to want to be aware of in terms of, giving notice to people and the responsibilities that you actually have when you are somebody's personal representative. So just a couple things to mention before I go too deep into anything. We do have a Q&A function. So if you do have any questions and you're participating via Zoom, please feel free to send in those questions. As I'm doing this, I can see them come up, so I can try to answer them as we go. If last time is anything to go by, we had a lot of really good questions. So I'm looking forward to that today as well. We also have some feedback forms for you to fill out at the end of this as well, so that you can, if anything today raises any concerns, or you just really want to come in and talk to one of us, it's an initial consultation form as well that you mark down and say, yep, I'm interested in setting up an initial consultation. Please reach out to me and set something up. We don't reach out to you if you don't fill anything out, so don't worry about that. But if you're at all interested, please feel free to fill it out. And those initial consultations are complimentary. We like to sit down and get to know the situation before we can even determine what a reasonable fee would be for something. So it does not cost you anything to come in and talk to us. And they're usually about 2 hours, give or take. It depends on the complexity of the situation, obviously. Some of the materials you'll have received or will be receiving, after this are kind of what goes through probate and what doesn't go through probate form, comparison chart, as well as our estate administration book that we've written. So it is a really easy to read through question and answer style book. So if you are administering somebody's estate or are just curious about what that entails, hey, here's this good little resource for you. So to get started, a personal representative is an executor. It's the same role. It's just what we in Wisconsin call it. That's what the statutes refer to it as. So I'm sure you've heard the term, oh, I'm the executor of somebody's estate. This is the same role. So the personal representative is somebody that is nominated to handle everything, that kind of be that overarching sort of administrator for all of the finances, all of the expenses, all of the responsibilities of going through probate. You can nominate a personal representative in your will. So if you have a will, you will have nominated a personal representative, assuming it was drafted properly anyway. If you don't have any plan at all, so you don't have a trust, you don't have a will, you don't have anything like that, you still will have a personal representative appointed for your probate estate. It's just you have not nominated anybody yourself, and there's potentially more uncertainty about who will be in that role because you have not nominated anybody. And it is really a nomination. So people have the opportunity to sign off on that personal representative, and by people I mean the beneficiaries of the estate, or anybody that would inherit from your estate if they hadn't been disinherited, if they were just to inherit if you passed away with no plan at all. So the court gives people the opportunity to come forward and to object or just to sign off on that appointment. Now, an objection does not mean that you won't be named as that personal representative in the end. It just means that you have somebody objecting to that appointment, and the court will hear any reason why that objection is occurring. But they do give a lot of weight to the person who is nominated in that document or in your will. So, you don't have to worry about, oh man, there's this ridiculous objection to my son or my daughter being my personal representative. Is that going to get in the way of them helping my estate, get through probate and all of that? And not necessarily. I mean, if it's a reasonable objection, or there's a legitimate concern over that personal representative's ability to do the job correctly, or, if there's any sort of, fraud concerns, or, things like that would get in the way of somebody being a fit for that role, that can certainly be a reasonable objection. But if it's just, well, I don't like them and I think they're going to try to cheat me, but there's no real reason behind that, that appointment is given a lot of weight. They weigh that heavily against any objections. The same thing when you would nominate like a guardian for a minor child, right? I do already have an initial question here. So what are the steps to reject object to the appointment of a personal representative, and who can object? So when a probate is opened, so you first file the will, and before that personal representative is appointed, you have to give notice of that nomination to all what's called the interested parties. So the interested parties are the people who are listed as beneficiaries of the estate through the will, or would be interested parties, or would be beneficiaries of the estate if the will was invalidated. So what that really means is, if you disinherited a son or a daughter, and they would inherit had you not disinherited them, they can be given notice of that appointment. So those are the people who then, if they do not sign off on that appointment, they can file an objection with it. So usually there aren't too many objections, as long as the family gets along. If the family doesn't get along, there still has to be a valid reason to object. And like I said, that would have to be some sort of concern about fraud, or, some inherent unfairness, or, something along those lines. It couldn't be just, I don't like the person they named. That's not a valid objection. I'm sure people have tried to object for that reason, but it's not really a valid objection. So who can object are the interested parties. And again, those are the people listed as beneficiaries of the will or of the estate, or who would be beneficiaries of the estate had the will been declared invalid because it was not signed properly or something like that. In Wisconsin, there's something known as heirs at law. Essentially, think of that as, if I died with no plan whatsoever, here's who would inherit from me. Those people are potentially interested parties as well, if they're still living and all of that. So those people can object. Again, it's not overly common, honestly. Usually people sign off on it, as long as there's no big concern. And the best thing you can do is to actually nominate somebody for that role, and in a will, so that is given a lot of weight. And there's also a lot of provisions you can put in wills or in trusts or plans that basically say, beyond a fair objection, or beyond a reasonable, delay of the process, if somebody contests the validity of a will, or contests, whether or not you had capacity to sign that will at that time, and it is proven not to be correct, there are provisions called no contest clauses that you can put in plans that essentially say, hey, if you're inheriting from me, and you contest the validity of this, you may not get anything at all. You may lose your right to inherit. So there are some things you can do to make sure that you nip any objections in the bud too. But that's within reason. If it's proven to be a valid objection, the courts are supposed to be places of equity. So if people have a fair objection, they're not going to necessarily say, well, now you lose your inheritance because it was a reasonable objection. It really depends on the opinion of the court at that time. But there are a lot of at least scary clauses you can put in there to try to stop someone from causing a problem before they do. That doesn't work as well, obviously, when you have people who are being disinherited already, because then what do they have to lose, right? So that that can be something to keep in mind. But okay, so another question here, is it required that all beneficiaries either sign off or object? No, they're given a period of time. So if they don't sign off by a certain point, they don't, you can't, delay the process forever. It's usually a couple weeks that they have to sign off on something. It can kind of depend. I've seen courts vary the dates sometimes of what that period is. It's the same thing where under the law, creditors are supposed to have, 90 days to come forward if they're creditors, but I've seen that date pushed out or, further than that too. So they're given a set date by the court where they have to return those objections or return those approvals. They can't just delay the process forever. So yeah, there is a time limit on all of these things, especially when the court's involved. They like to get these things through when they can. They don't like delays if they can avoid it. So once you are approved as the personal representative, though, once that, either all objections have been cleared or there aren't any objections at all, everyone's signed off relatively quickly, you receive what's called a domiciliary letter from the court, basically your documented proof that you have been appointed as somebody's personal representative, or as the estate's personal representative, rather. Think of it kind of like a power of attorney for finance for the estate, right? No bank in the world is going to let you take someone's power of attorney for finance in after they've passed and say, I'm the power of attorney, I should be able to handle the estate. So what you would do in it, and in exchange of doing that, or rather than doing that, you would take in the domiciliary letter as proof that, hey, I'm the personal representative, I can administer this estate, I have access to these previously frozen bank accounts, right? In order to pay expenses administratively, or pay creditors, things like that. So once that occurs, you're able to act a little more freely. Again, there are still things to be aware of with time limits, as I mentioned. I actually just mentioned one of them, that kind of creditor notice to creditors that you have to give. So it's usually around a 90-day period of time. Again, I've seen it pushed out longer than that. It's supposed to be 90 days, but occasionally it's a little, depends on what the court puts as the date. But you make notice once a month, usually in like a newspaper or something like that, basically saying, hey, John Smith passed away, and if there are any creditors, send the notice, to the probate estate, and file a claim with the probate estate. If those creditors do not come forward by that deadline, their claims are absolved. I mean, they no longer can try to attach a lien to an estate or recover against an estate in that instance, because they didn't respond in time. There was actually a situation not that long ago. One of our paralegals who handles our probate and settlement department, she was explaining where a bank was months late on a bill and still tried to file it, and we had to basically tell them, no, you can't. It's too late. You're past that point of making a claim. So sometimes it pays off, right, to wait that whole time, because people don't actually always make those filings with the court properly. So I mean, obviously you have to notify any known creditors too. So it's not just like this public notice where it's, hey, this nebulous, if there are any creditors out there. I mean, you do that as well. But if there was like a known hospital bill or a known mortgage or, line of credit or something like that out there, you have to notify them directly. You are obligated to do that. So there are some things that you need to be aware of in terms of, that brings me to my next point, as a personal representative, of how to manage, giving notice and who to give notice to on various issues. So I mentioned the creditors. The other thing to be aware of is you have to, give notice to beneficiaries if you can find them, right? I mean, obviously, sometimes you may not have an updated address or things like that, and that's within reason. Obviously, we try to find beneficiaries if that ever occurs, although usually we have an address from the person who initially signed the will. So you have to give notice to people who are entitled notice. You have to make sure that you're doing proper accounting for expenses and payouts and things like that, because you have to file what's known as an estate account. and estate accounting, so that you say, okay, here's what we started with, right? Here's all of the assets that are going through probate, and here were the creditor expenses, and were my administrative expenses that I took. So that, here's the lawyer's fee, or here's the, travel expenses, potentially if I had to travel in my role, any sort of expenses like that. You make accountings of those because you do have to file that with the court. And that's there to make sure that you, as the personal representative, were not, committing fraud or taking somebody's estate money and spending it on exorbitant expenses that just did not need to be paid. Those are the types of things that you don't want to see on a estate account, because that is obviously going to be challenged by either the court as unreasonable, or it opens it up to a beneficiary contesting something that you were not, doing your due diligence or doing your duty correctly. So those are the types of things that you need to account and report on. And obviously this is a lot of work, which is a big reason people come in and talk to us or hire us to help with somebody's probate estate, because it is a lot of work and there are a lot of deadlines and accounting requirements that either people just don't have the experience doing, or they don't want to do it because they're grieving and it's hard enough to go through that. So if somebody comes in and hires us, we're taking care of a lot of those things, other than the literal signature that you need to sign off on things. We're creating the estate account. We're making that notice to creditors. We're working with appraisals for like real estate, for example, things like that. So it's really important to make sure that you're on top of those things, but it's also completely okay to say, I really, want help with this because it is a lot of work. So that's my little piece there for, why you might want to hire an attorney. But if you are going it alone, there's only so much help that the court is allowed to give you, right? They can't tell you everything. They try to help, I've seen, but it's certainly not, it's not to the same level, and they have a lot of things going on too. So they're not going to hold your hand as much as potentially an attorney would with it. And I don't mean that in a bad way. I mean, hold your hand as in, they're taking care of it for you, right? So some things to keep in mind, though, as a personal representative, and this is something we talk about on this chart here that you'll be receiving from us, is what goes through probate and what doesn't. A lot of people think that, okay, so I have this will drafted, that's going to direct every asset I have, right? That's, that guarantees those people inherit from me in those percentages or in those amounts. Obviously barring estate size, right? You can't give more than you have, but that isn't actually what occurs. So a will is specifically a list of instructions to the probate court of how you want your probate estate to be handled and split up. If something does not go through probate, it is not directed by the will. This can cause a problem for personal representatives. It can cause a problem with people's intended outcomes of their estate. It can cause, a whole host of issues. So I'll kind of try to summarize some of those for you so that you can understand from your side of things as a potential personal representative, but also, if you're looking at your own will, making sure that your plan works the way you intended. So a lot of people with a lot of accounts, bank accounts, IRA accounts, life insurance, things like that, they don't have them going through probate because they have beneficiary designations on them. They say on those accounts, when I pass, pay directly to, these individuals in this, fractional share and this percentage amount to each person. And that's okay for some assets. For example, you don't want an IRA or a 401k, those types of assets, to go through probate, because when you send one of those assets through probate, it can force a 5-year payout of all of the account. Under the current law, beneficiaries get, generally speaking, a 10-year payout for IRAs or 401ks when they inherit them. So you'd be cutting that in half potentially by directly sending it through probate. So that's an example of an asset you don't want to go through probate. But things like checking accounts, savings accounts, potentially life insurance, but that's going to be situationally dependent. Those types of things you may want to go through probate. And the reason is you want the personal representative to have access to those funds as the personal representative to pay expenses. A lot of times the personal representative is also a beneficiary, but not always. So the most common thing that I see with wills is one of the only things going through probate is real estate, because those don't tend to have beneficiary designations on them. So if you have a home going through probate and there's any mortgage remaining, or there's utility bills ongoing, things like that, but there's no money, no liquid cash in the probate estate, you as personal representative, where do you pay? What funds do you have to pay for those expenses? Especially if you yourself are not a beneficiary and have not inherited anything, where are you getting that money to pay those expenses? And this would potentially be very true for somebody who has, only minor beneficiaries, right? You're not going to name a minor child as a personal representative, but there are other situations where this comes up too. But even if as a personal representative, you are a beneficiary of any account, the point of the having money in the probate estate to pay for expenses out of, a chunk of money before it splits up to anybody is so that those expenses are distributed equally amongst those beneficiaries, or fairly amongst those beneficiaries. If you're a beneficiary and a personal representative, and you're only using your share to pay expenses, there's no guarantee that you'll actually be paid back. The court will try if there are funds to do so, but there's no guarantee, right? Okay, so I just got a question. Would it be appropriate to object to a personal representative who was the power of attorney and changed the beneficiary form going to the estate and a friend to his adult son? Possibly. I mean, it based off of that, it sounds like there's some that is weird, especially if a beneficiary was not what the original beneficiary was of the estate prior to that. There would need to be investigation into that to know all of the facts and everything. But, for example, in our power of attorney forms, things like that, we do talk about, or we limit the power of what a power of attorney is able to do so that they can't disrupt estate planning. I mean, that would be a question that if at the end of this, you really want to sit down and talk with one of our attorneys, that would be definitely something that, that's where you can call and talk to us, or if it's something if it's more of an actual fraud investigation, we can at least get you a referral for, because that's certainly a little alarming if that's the case. So it may be something we can get you a referral for, if not something we can talk about ourselves. That kind of thing we can talk about a little further. But so back to like the probate estate, things like that, and putting expenses under the control of the personal representative. That's the type of thing where you don't want the personal representative themselves to bear the brunt of those expenses, and they're never personally obligated to pay those expenses, but you don't want to have potentially their share, if they're also a beneficiary, end up not being what you intended because they had to pay more of the expense themselves and there was nothing left to reimburse them with, right? So some things you actually do want to go through probate if you are using a will as your plan. Now, that's specifically for will plans, right? Because we're talking about personal representatives. If you have a revocable trust or another type of trust-based plan, that the answer to that of what's correct there is going to be entirely different. But so I'll keep that for another topic as well. But specifically, if you are using a will and that is your only estate planning document and you don't have a trust, make sure that you are directing your assets properly so that at least the personal representative has some funds available to them. Those are the types of things that definitely most commonly go wrong, where there just isn't something to pay for the probate estate. I've seen before where I've had somebody try to update a beneficiary designation on an account for I believe it was like a checking account, and the bank said, no, don't worry, we don't want that going to the estate. We want it going to you because you're the personal representative. Well, that was the incorrect thing to do. So just because the bank is telling you to do it doesn't mean that's what you want to have happen according to your plan. It's really important to make sure that those things are designated properly and that you're talking with your attorney who drafted the plan to make sure that that's correct. And I'm not trying to pick on banks like they're doing this out of malice or anything like that. It's just sometimes it comes down to a lack of understanding of the rules or how probate works. I wouldn't expect everybody across the world to understand what probate even is, right? So it just keep in mind that when you're functioning as a personal representative, you want some cash available as that personal representative. But the other thing, if it's your will that you're talking about and you're worried about people getting something, that kind of thing, making sure that those percentages actually occur the way you want them to is important. And if you on certain accounts only name certain people and you don't name all of the beneficiaries in your will, well, that can be a problem too, because now those accounts as the beneficiary or with those beneficiaries are going directly to those beneficiaries. So they're avoiding probate and therefore they're also avoiding the will. If they don't go by the terms of the will, there's no guarantee that those beneficiaries will inherit the way you intended. There's a good example of this occurring, just to give you an idea, where somebody, I heard the story, somebody had, CDs, certificates of deposit for each grandchild, and they would, take one when it came due, whenever they needed money. But the problem is since each CD had a different grandchild on it, they were potentially accidentally disinheriting their grandchild every time they did that, just because they were using the account that was coming due. And that's just kind of shows you, okay, well, if you really wanted those grandkids to inherit equally, send some of that money, to be in accordance with your will through the probate estate. Again, if this person's plan was to use a will. So a lot of these things can really get out of alignment, but if you're acting as personal representative, it's really hard on you to go and force these people to give money back because, quite frankly, they're under no obligation. Once that money gets paid out to them as a person or as a beneficiary, through like a payable on death or a transfer on death, those types of things can, they're under no obligation to give the money back to the estate. They may not be able to, it may not be out of malice, they may not be able to, because they have their own liabilities where gifting would cause them problems. So, that's something, if you know you're named as somebody's personal representative, especially like a parent's personal representative in their will, talk with them about that and say, hey, let's take a look at these beneficiary designations. Let's make sure that your plan works the way you intend it to. Because a lot of people get the will drafted. They don't look at their beneficiary designations. They don't, take all of that into account, and they think they're covered and that everything is going to work out just fine. But that's not necessarily the case if things are not properly aligned. Whenever we do, will-based planning or trust-based planning, I mean, part of what we're doing when we're drafting those is to make sure, that everybody has, their assets aligned properly. So I do have a question. If someone is designated in the will as the beneficiary, does it need to go through probate or wait to sell the house until probate is completed? So if the house is going through probate itself, like they're not named on like as the owner on a deed or something like that, a house can be sold as part of probate. So usually what you want to do is as the personal representative, you'll want to get an appraisal or maybe a couple appraisals to make sure that, the value is fair and accurate. And then if you're trying to sell it, you can sell it as part of that probate. And then the beneficiaries can get those shares of the estate or shares of the home through the estate. But, you generally don't want to dole out the ownership of the home before the probate's even started. I mean, that would be almost impossible to do, honestly, because no deed in the world would let you do that. If the person has passed, right, they have to sign off on it. And if they've passed, it means that house is going through probate. So then the personal representative is the one that has, the authority to make distributions, pay expenses, all of those types of things. So you can sell the home as part of the probate, or because the sale of the home would take so long too, I mean, that, in today's market, it can be really quick or it can take a long time. So it just kind of depends. but you can always give out the ownership of the home on a deed too as part of a probate, and then once it's sold, have have those new owners, the beneficiaries of the estate, get paid accordingly. Okay, so I am getting close on time here, but so I'll just finish up by saying, the personal representative role is responsibility, and it can be a lot of responsibility, depending on the situation, and it can be a lot of stress if you are especially dealing with any sort of conflict in the estate. That's not to say don't do it. I'm not trying to scare anyone away from it, but it can be a really good reason to seek help with it, right? You don't know what you don't know, and that's true of everybody. It's true of myself, and so you need to find somebody who can help you, who really focuses their practice on estate planning or probate administration, those types of things, because without knowing all the ins and outs of it, you may end up dealing with something you're not aware of how to fix, right? And that's what people like me are here for. So if anything here has raised any concerns, or you have any more questions or anything like that, please feel free to reach out to us. We have an email for learn more at hooperlawoffice.com if you have any questions that are like quick questions, or if you have any issues with your own estate, or parents probate or something like that, please feel free to reach out to us. Like I said, we don't have any fees for our initial consultation. They are complimentary. So I believe our upcoming topic for our next week's webinar is basically planning for those that you love. We're in the month of February, Valentine's Day is coming up. So we're planning for those, in your family that you love, making sure that they're protected through your estate plan, that you're accounting for all of the sorts of things that can go wrong when somebody inherits money if they're not properly protected, right? So that's going to be our topic next week. So I look forward to seeing you guys then, and